Good morning, good afternoon, and welcome. I'm Megan Burton with Foley and Lardner. I'm pleased to welcome you to today's Environmental Law Update web conference series. This program is titled The New Toxic Substance Control Act: What Industries Need to Know About the Changes in the Chemical Regulation. Before I turn this presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit your written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help widget below the presentation window, which is designated with a question mark icon. A copy of the PowerPoint presentation is available in the resource list widget. Foley will apply for CLE credit after the web conference. To be eligible for CLE, you will need to remain on the web conference for the full 60 minutes and answer the polling question during the program. Please note, certificates of attendance will be distributed to eligible participants approximately 8 weeks after the web conference via email. As a final note, those seeking Kansas, New York, New Jersey CLE credit are required to complete an attorney affirmation form in addition to the polling question that will appear in the program. Please enter the 5-digit code that will be announced during the presentation on the form and return the form to Megan Burton at mburton@foley.com immediately after the program. And now I would like to turn the presentation over to our speaker, Louie.
Hi, everybody. First of all, thank you all very, very much for joining us for what I hope you'll find a very interesting presentation about the TSCA amendments, which we'll probably refer to as either the new TSCA or the TSCA amendments throughout the presentation here. First off, we'll give you a quick introduction to the three of us that'll be speaking today. As you can see on the screen there, my name is Louie Thorson. I'm an associate with Foley and Lardner's Environmental Regulation Practice Group, and my practice involves a number of regulatory compliance issues and other related environmental matters, including issues related to TSCA.
Hi, my name is Amanda Beggs, and I'll also be speaking today. I'm also an associate here at Foley and Lardner in the Environmental Regulation Practice Group, and my practice focuses on a variety of environmental laws and compliance issues.
All right, and to round it out, my name is Sarah Slack. I am also in the Foley Environmental Practice Group, and I'm going to be speaking today also. And at this time, I think I'll turn it over to Louie to get us started. Louie? Great.
Thank you very much. So just to give you a very quick background here, an overview rather, of what we're going to be discussing today, thought it would be helpful to first start with a very brief just background of what TSCA is, its history, and talk through some of the deficiencies that led to the TSCA amendments that are the subject of today's presentation. Apologies to those of you who already know it, but we thought it would be at least good to set the stage, give a little context for the second and third parts of the presentation, which will be a discussion of the key changes that occurred in the TSCA amendments and kind of a walkthrough of the more nitty-gritty details of what's changed from the original TSCA that was passed in 1976. And then finally, we'll go through the timeline for implementation, including the applicable statutory deadlines under the new law, and give our thoughts and some details on what we think the implications are for industry and why it matters to all or most of you that are attending the conference today. So with that, we'll move into the first part, which is the background of the original TSCA. So TSCA was originally passed in 1976, and just to kind of give you a sense of what I'll talk about here in this section, it's we'll talk about what provisions it had when it was originally passed, how that's kind of evolved over the years, particularly with relationship to other environmental laws that EPA enforces. And we'll talk a little bit, obviously, about who and what is regulated. And then, like I mentioned, we'll walk through what are at least some of the perceived deficiencies, if not the actual deficiencies, that have come to light in the 40 years since the Act was originally passed. So as I mentioned, the original law was signed in 1976, and it had as its primary purpose at that time to really regulate the safety of chemicals that enter into commerce and ultimately get incorporated into, many of the everyday products that we all use. It was, seen as ideally a way for EPA to serve as a gatekeeper for these chemicals and make sure that new chemicals that were introduced in a way that was safe and that the chemicals were at least going through some kind of analysis before being sent into commerce. The law applies to entities that manufacture, process, use, import, or export chemicals in their products or just produce the chemicals themselves. Depending on which chemicals you're dealing with, there can be more extensive requirements, remediation and disposal, for example, if you're dealing with PCBs. And there are also some exclusions in the original 1976 Act: food, drugs, cosmetics, pesticides, and likely some others as well. And those were excluded primarily because there were other agencies or other laws already on the books that were dealing with those types of products, and so they didn't want to overregulate. As we can see on the slide there's been not a lot of change since the law was originally passed in 1976. There have been both regulations and statutes that have been passed with respect to very specific chemicals like asbestos, radon, and lead-based paint. But those, as I said, they're very narrow, relatively speaking, and so for the most part, the law has functioned in a manner since 1976. So I want to walk through some of the main provisions from the 1976 Act and the kind of regulatory scheme that it set up when it was originally put in place. Essentially, it relied on manufacturers to notify the EPA with what's called a PMN, or a pre-manufacturer notification, to let them know we've got a new chemical that we'd like to introduce into the marketplace. And that triggered an evaluation process by the EPA to evaluate that chemical, take a look at its safety implications, and try and evaluate the risk as best as it could. And then, as you can see there, before they could actually regulate it, they had to prove that it posed a potential risk before it could require the manufacturer to provide more information or perform additional testing and satisfy it. EPA was also required under the original TSCA to conduct a cost-benefit analysis, that it had to consider health, environmental, and economic effects of any regulation that it would pass related to the chemical. So you can kind of see it was a process that really put a lot of burden on the agency, on EPA, and ultimately, as we'll see in the next slide here, even if they overcame that burden in terms of evaluating the chemical, they then had some limitations on how they could actually regulate it. First, they had to choose the least burdensome level of regulation, least burdensome involving any number of factors, not least of which was cost on the manufacturer, because obviously they were trying to balance industry versus regulation. And then they also had to go through the relatively rigorous administrative rulemaking process in order to regulate those chemicals. And as many of you probably know, that can be quite lengthy, quite involved. It can involve multiple rounds of information collection, proposed rules, commenting, responding to comments, and ultimately finalizing rules. And then it can involve involve legal or judicial challenges to it as well. So it can be a very, very burdensome process, lots of agency resources involved in that, and we'll talk in a little more detail about that a little later on here in the presentation. Another major provision that's worth highlighting too is that if these rules did get through that rigorous rulemaking process, they did preempt any conflicting state laws that were passed. In practice, that hasn't been, I think, that much of an issue, except with respect to, like I mentioned, some of those narrow categories of chemicals that EPA has gone through. But there at least was some attempt here to try and give industry a more uniform structure. And I think, as we'll talk about a lot more later, that played a big role in the current amendments and how those are going to play out. So, like I mentioned, this is EPA's, this gives EPA the ability to serve as a gatekeeper to regulate chemicals that are used in our everyday products, the sale, the manufacture, the import, the export, the use of those chemicals. Given TSCA's limitations, however, there's been a proliferation of other environmental laws that have been used to maybe regulate a lot of these same chemicals in other ways. And some of those include, you can see here, EPCRA, which is the Emergency Preparedness and Community Right to Know Act, which involves, sets a number of obligations on manufacturers to be aware of the chemicals they're using, to make public filings related to those chemicals, to notify about releases, and generally make the community aware, essentially, of what they're doing in their facilities. RCRA, which deals with hazardous waste disposal, so kind of regulates the back end of these chemicals as opposed to the front end. CERCLA, which is obviously the Superfund cleanup, dealing with releases of chemicals. FIFRA, which, as I mentioned earlier, is one of those laws that was already on the books when TSCA was passed and was dealing with pesticides specifically. The Clean Air Act, which is on here primarily to reference asbestos, and even though there were attempts to regulate asbestos under TSCA, there's also federal NESHAP standards that apply to asbestos under the Clean Air Act. And then the last one there is the Consumer Product Safety Act and the Food and Drug Administration and the acts that they enforce, relating primarily to consumer products, obviously, and dealing with essentially safety issues related to those, and that may include chemicals. The CPSC, the Consumer Product Safety Commission, for example, has limits on BPA and phosphates and other things that are used in children's products. And so there's some overlap there, and a lot of people, I think, the CPSC has probably done a lot more in that regard than EPA has been able to do under TSCA. So I've kind of already mentioned this already, but basically it was broadly applicable. TSCA was when it was passed in first 1976 that anybody who was introducing a chemical substance or a mixture into active domestic commerce was covered and had to file those PMNs like I discussed earlier. But one of the bigger shortcomings when it was passed in 76 is that it required evaluation of only new chemicals that were introduced after it was passed, and obviously that likely represented a legislative compromise at the time, given the number of chemicals already in use. And also may have been some negotiation on the government's part in not wanting to have to review all those chemicals given the burden that was associated with that. So like it says on the slide there, if it was already in use as of 76, there really wasn't any review applied at the time the current TSCA was passed. Now that there are exceptions to that, if, for example, there was a chemical in place prior to 76 and there was a significant new use that was contemplated for that, then you were subject to a similar PMN process, and EPA would evaluate that new use and ultimately would issue what's called a SNUR, a significant new use regulation that would describe, how the new chemical could be used, or if it was import limitations or production limits, or any number of things that would bring them under the current TSCA if you had a significant new use. So last, for my portion here, I want to just walk through some of the perceived deficiencies to the extent I haven't already talked about them anyway. And you can kind of get a sense of why all the changes that Amanda will talk about next were perceived as necessary anyway by both industry and EPA ultimately, and also the various stakeholders who wanted a more thorough regulatory scheme. The first one there, created unwieldy, varied, and conflicting state regulations. Examples of that include Prop 65 in California, the more recent green chemistry initiative that California is doing. There are various states that have imposed, for example, requirements on lead in products, both children's products and more generally. And it could be as simple as just labeling to let people know that your product contains a chemical like lead, or it could be more significant than that. But ultimately it made it somewhat problematic for manufacturers having to worry about essentially 50 state surveys every time they manufactured a chemical, or states rushing in to fill the void of the many chemicals that were not covered because they were already in place when the new act was passed. The second one there, failed to evolve with science and industry. It's pretty obvious based on its face that if it hasn't changed a lot since 1976, we've obviously come a very long way since 1976 in both the science of chemicals and the industry and manufacture of those things. So it's something that everybody viewed as pretty desperate need of update. We've already talked a little bit about this, but just to highlight it again, the process that EPA had to go through in order to regulate both the cost-benefit analysis and then ultimately having a least burdensome requirement before they could regulate, when they actually did issue regulations, all of that just puts a lot of burden on an agency, EPA, that typically works with constrained resources. And same thing for that fourth bullet point there. Once they finally got through that red tape, so to speak, they had even more red tape in the form of actually going through administrative rulemaking. Mentioned this before as well, but this gives you the number that there were approximately 64,000 chemicals in use prior to 1976 that EPA basically couldn't evaluate based on their uses at that time. While the SNR process maybe provided some additional ability to regulate post the passage of the act, ultimately the uses of those 64,000 chemicals were not really being evaluated, which obviously many people, particularly environmental groups and other similar stakeholders, viewed as a huge hole. Provided no framework for prioritizing the most dangerous chemicals. That kind of bears out in some of the individual chemicals that have been regulated, asbestos and radon and lead-based paint and those things, that it essentially required additional statutory or regulatory action to prioritize, which is not really a very efficient and effective process. California's green chemistry initiative, I think, is somewhat of a model to try and fix that. The whole point is to evaluate what are the most problematic chemicals and go after those first, or the most problematic products, which was really lacking in the 1976 TSCA. And then because the current chemicals as of 1976 were not subject to regulation, EPA didn't have the authority to require testing or information on those products. And so on those chemicals, there was obviously very limited information then that EPA could require, usually limited to the SNR process. So again, another hole that was sought to be filled based on in the new amendments. I mentioned a couple of times EPA's constrained resources. When information is submitted under TSCA, you can very freely mark it as confidential business information when you submit it, and that when you then have people requesting that information, environmental groups and others under FOIA, you can get a very big backlog at EPA of reviewing those claims. So that was another kind of agency resource issue. Similarly, didn't provide explicit protection for especially vulnerable groups. Children and pregnant women in particular are often cited here as examples. And another kind of version of what we've already talked about, that there was no explicit duty to review existing chemicals, and you didn't have enforceable deadlines. And so EPA, again, with constrained resources, was often slow and really did not ultimately engage in effective regulation. I think that's kind of the best way to summarize it all, that there was really just a lack of effective regulation. So before I turn it over to Amanda, just to walk real quickly through the history of the current amendments. We only go back on here to 2015, but there's articles and things out there that have basically traced this back to as early as 2004 to give you some sense of how long these have been in the works and the amount of negotiation that has gone on between industry and the legislature and various other stakeholders. But ultimately, that process was highly negotiated and resulted, as you can see, in June of this year, in a very amazingly bipartisan votes to ultimately pass the TSCA amendments, and something that I think was pretty hard to foresee given the polarized Congress that we have, but ultimately has led to what Amanda will talk about next in terms of hopefully what everybody is hoping are quality changes to the way TSCA works. So with that, I'll pass it over to Amanda.
Thanks, Louis. With that background, we're set up well to talk about the key changes under the recent amendment. And here I've just provided sort of a brief overview of those key changes we'll be touching on today, including the changes to the chemical inventory, prioritization of chemicals, risk evaluations for chemicals, the expanded EPA authority on submitting confidential business information, levying fees, and preemption of state laws, and then the new limits and prohibitions for mercury. So first, we'll address the chemical inventory. So the existing TSCA inventory will remain the same, but EPA is responsible for designating those chemicals as either active or inactive. And active chemicals really are just those that are active in domestic commerce. And EPA will be using information from manufacturers and processors of chemicals to determine which chemicals in the previous years that they've manufactured or processed are in fact active. And only those active chemicals will be addressed. That leads us to prioritization. So once a chemical is determined to be active and is listed on the TSCA inventory as active, the EPA will make a designation of the chemical as either high priority or low priority. And the EPA will start with 10 high priority chemicals that it designates. And there's a new focus on the most dangerous chemicals such as carcinogens or those stored near drinking water, other dangerous chemicals. And basically, I'll just give a brief overview of the process then. So once a chemical is designated high priority, the EPA will conduct a risk evaluation, which we'll touch on here in a minute, of that chemical. And if it poses an unreasonable risk, the EPA has to issue final rules to manage those risks in that chemical. Low priority chemicals are listed, and there's no further action for those chemicals, but they can be elevated to high priority if new information comes to light. And the EPA, which Louis already sort of touched on, will be looking at all chemicals that are inactive, even those that existed prior to 1976. And within 3.5 years of the enactment of the amendment, EPA must designate 20 high priority chemicals and 20 low priority chemicals. And that leads us to the risk evaluations for those high priority chemicals. So once a chemical is designated as high priority, that triggers a mandatory risk evaluation. And EPA will look at the high priority chemical based on all available hazard and use and information and data that it has, up-to-date data that it has, to determine whether that chemical poses an unreasonable risk, which we'll talk about that standard in just a minute here. And as I mentioned before, the low priority chemicals, while they don't go under these risk evaluations, they can be elevated if later information shows they need that. So risk evaluations, they're performed for high priority chemicals, but then also there's a process under the amendments in which industry can request that a chemical be evaluated. And that process is laid out in the amendments, but there are costs associated with those manufacturer industry requests. And for those chemicals that are listed on the TSCA work plan, which was developed in 2012 and has since been updated in 2014, EPA identified several priority chemicals. If manufacturers ask for those to be evaluated, they are responsible for 50% of the cost with that evaluation. But any other chemical that a manufacturer wants evaluated, they're responsible for 100% of those costs. Additionally, the requested risk evaluations by industry don't come without some limits. EPA is granted discretion on whether they're going to approve or undertake those risk evaluations. And EPA is still required to be conducting 20 risk evaluations at any one time, and the manufacturer requested evaluations don't count towards that minimum. But under the amendments, they are also required to be a certain percentage of the amount of risk evaluations that EPA is conducting. So up to between 25% and 50% of the risk evaluations should be manufacturer requested evaluations. So if EPA is conducting 40 evaluations for high priority chemicals, that would mean that manufacturer evaluations could account for an additional 10 to 20 risk evaluations that are occurring at any one time. And now that we've sort of designated the categories that risk evaluations are conducted for, we can talk about the standards for those risk evaluations. So when there's a high priority chemical or industry has requested an evaluation that EPA has agreed to, the standard is now an unreasonable risk standard, so it's a risk-based standard, which is different from the cost-benefit analysis or the least burdensome standard that Louis touched on previously under the original act. So once EPA determines that there's an unreasonable risk based on the risk evaluation, then EPA has to enact final rules on how to manage the risk and how to manage the chemical. And notably, the rules are not just for the average person, but they should be particularly protective of vulnerable groups as well. I will note that the EPA still does consider costs and benefits and economics in tailoring the regulations. It's just that the standard is more focused on a risk-based standard under this unreasonable risk standard. So the next major change is just sort of generally the expansion of EPA authority under the recent amendments. And these are just some of the things that I'll be touching on in that regard. So some testing requirements, regulation of new chemicals and new uses, regulation of existing chemicals, which touched on quite a bit here with the prioritization process and the risk evaluation, and then just some broad overarching changes that are under the amendments. So first, EPA can impose testing requirements by rule, order, or consent agreement for any particular chemical. And the standard is now basically EPA will issue a statement of need as to why the testing or information gathering and data gathering is required. And this is a tiered testing process. So EPA can require that a chemical be tested with an initial screening, and then at that point it'll make another determination about whether additional testing is required and can require that at that point. And then regulation of new chemicals and uses. Louis mentioned this a little bit with the pre-manufacturer notice. So manufacturers and processors can't produce a chemical until EPA approves of the chemical, and EPA has 90 days to do so. And EPA must make an affirmative finding on the new chemical or any significant new uses of existing chemicals before they can be introduced into commerce or the marketplace. And then at that point, EPA can take a range of actions. They can ban the chemical. They can include limitations or restrictions on the chemical, or require additional testing at that point. And then with regard to existing chemicals and uses, like I said, I won't go back over the prioritization process, the risk evaluation process, but both of those are two key changes for existing chemicals. And then also there's the initial set of work plan chemical assessments. So EPA is required to be conducting risk evaluations for 10 of the chemicals on the TSCA work plan from 2014. And there's also an expedited review process for chemicals on the TSCA work plan. So within 3 years, EPA must have proposed rules to manage the risk of certain chemicals on the TSCA work plan list that score high for persistence or bioaccumulation. And this is one of the big changes, and it seems to be a theme throughout this presentation as well, is just for existing chemicals, thousands of chemicals that were in existence prior to 1976 were previously unregulated or unaddressed, and now they're addressed in several ways under the amendments. And then just some broad changes that are sort of throughout the amendments and the language is that now EPA has the authority to compel action through orders instead of the rulemaking process, which we know can be cumbersome and time-consuming. So it increases the efficiency and likely the amount of regulation that EPA can do under TSCA. And while rulemaking and consent agreements are still available, they're just not required, and orders can be issued to regulate. Additionally, there's the general authority to regulate TSCA in articles and not just the chemical itself. EPA has had this authority, but it has rarely used it. But with this expansion overall of EPA's authority, it's likely that articles could be addressed with more scrutiny. And then just sort of to mention, while there is a trend that under the amendments, the EPA's standards are kind of relaxed and burden for information gathering and data gathering, EPA still has the burden to show that the regulations they enact or they promulgate are within the letter of what the TSCA requires. The next key change relates to confidential business information, or CBI. And Louis did touch on this previously, but under the law, previously the law said you could not mask the chemical identity or the name of the chemical and health and safety studies, but EPA often did that. The CBI claims didn't have to be substantiated prior to submittal, so you could just mark it as confidential and submit it, which often led to people asking for that information later and EPA having to review that information to confirm it was confidential or not, which created a backlog. That's changed, and now chemicals and mixtures are explicitly allowed to be masked in the identity of those where the EPA allows it or where it's been justified to the satisfaction of the EPA. And all regulated entities that are submitting confidential business information must provide an upfront justification for that. And I believe Sarah is going to talk a little bit more about the specific things you might include in that substantiation, but you have to do it up front. And then CBI claims also expire after 10 years unless they're adequately reasserted. So there is a time limit, and that information can be released after that time period. And then also under the amendments, the EPA can release or share some of the CBI information with governments or health providers or emergency responders if the information is deemed critical. EPA is also now allowed to levy fees under the amendments, and they're able to levy up to $25 million in annual user fees from regulated entities. And those regulated entities that would be required or that EPA can levy fees from are those manufacturers and processors of chemicals who submit test data, submit a notice of intent to manufacture a new chemical or a significant new use of a chemical. Those chemical manufacturers or processors who have risk evaluations ongoing for their chemicals, or those members of industries that request that risk evaluations be conducted. And then EPA can use these fees to defray up to 25% of the costs of the implementation, and then the rest is supplemented by congressional appropriations. And another key change here is preemption of state laws, and this was a hotly contested issue during the bill throughout its whole life until it was passed. And under the original TSCA in 1976, only final federal rules preempted any conflicting state law. And as we sort of touched on, the EPA had not really tested many chemicals and it hadn't issued many regulations, so preemption of state law under TSCA was pretty much non-existent. But under the new amendments, a state may act on chemical risks that EPA doesn't specifically address. So those laws aren't preempted if it's not specifically addressed by EPA. And additionally, preemption only applies to the scope of the EPA law that's rule that's contemplated. So if the EPA regulates only an industrial use of a chemical but not a household use, the state may still regulate the household use of that chemical. And then additionally, when an EPA rule and a state law are identical, the state and EPA have co-regulatory authority over that law as long as the state law doesn't exceed the maximum federal penalties. And then some state laws are grandfathered under the amendments, and therefore they're not preempted, which we'll be discussing more later. We've sort of touched on this, I believe, but state laws are preempted if the EPA demonstrates that the chemical is safe. So if the EPA says this chemical does not pose an unreasonable risk or it's safe, the state cannot then prohibit or limit that chemical. And then if the EPA takes final action on a particular issue, the state cannot then make a more stringent or even another regulation that addressed that same specific issue. There's also some general preemption within the amendments, but there's also a preemption pause. While EPA is conducting a risk evaluation of a high priority chemical, as we discussed previously, the state regulation for that chemical is paused, and the state cannot regulate it. If the EPA finds that that chemical is safe, then preemption continues. However, if the risk evaluation takes the EPA more than 3.5 years to complete, then the state can regulate that chemical. There are also preemption waivers that the state can apply for under the amendments, and the state can apply for a waiver of general preemption, the general preemption requirements, or in the statute, or the preemption pause in the statute. So EPA must grant a waiver of the preemption pause if the state enacts a statute or a final administrative action that prohibits or restricts the chemicals. And EPA may grant a waiver of the general preemption if there are compelling conditions and there won't be an undue burden on interstate commerce. And the EPA supports the decision of the state to regulate that chemical and that risk, then the waiver may be granted. Finally, the last key change I'd like to discuss here are the amendments, greater restrictions on certain mercury compounds. And effective January 1st, 2020, the amendments add certain mercury compounds to the export ban on elemental mercury. And the amendments require that the EPA publish an inventory of mercury compounds and the use and trade of those compounds in the United States, and then also report to Congress on those on mercury compounds. So those are some of the broad key changes under the amendments. And at this point, I'm going to turn it over to Sarah, who's going to talk about how and when those changes are going to be implemented, and also the implications for industry.
Great. Thank you, Amanda. Good afternoon, everyone. My name is Sarah Slack, and I'm going to talk next about the timeline for implementation, and then following that, I'm going to talk about some implications for industry. First, with respect to timeline for implementation, the amendments here to TSCA included a number of very specific timelines. And so with that as context, we thought it would be helpful as a practical matter to discuss what some of those timelines are. And then with respect to implications for industry, as both Louis and Amanda indicated, the changes to TSCA are fairly substantial. And so there's been a lot of talk about how that will impact industry going forward, and we thought that it would be helpful to discuss where we see those implications being most significant. So first, with respect to the timeline for implementation. So in the short term, as I think Louis indicated, the act was signed by President Obama on June 22nd, and immediately the new pre-manufacture notification review requirements took effect. I didn't put that those also apply to significant new use notices, NUNs, but those also took effect immediately with respect to those emissions. And so as a result, what that means is that EPA now has that 90-day window, which was consistent with under the prior statutory scheme, But one of the big significant differences is that if EPA reviews the submission information and determines that a chemical can be used in commerce and they're not intending to do any limitations or restrictions on that use, it can get back to a submitter in sooner than 90 days. So for instance, in 30 days, and say, you may begin to manufacture or use this chemical or process it in commerce. And that is a change that benefits industry, because previously, even if EPA determined in a time period shorter than the 90 days that that a chemical could be used, the manufacturer or importer still had to wait those 90 days. So effective immediately, if EPA can determine in a shorter time period that a chemical can be used, there's no longer the requirement to wait that full 90 days. What also took effect immediately were the new confidential business information requirements that Amanda mentioned. And I'm going to talk more about those in a few minutes as well. But those are fairly significant and require that upfront substantiation. So to the extent that information is being submitted or new PMNs or SNUNs are being submitted, the new CBI requirements went into effect immediately as well. Also on the horizon, Amanda was just talking about the changes with respect to mercury. And one of the first requirements under the amendments is that EPA must provide a list of mercury compounds that will be prohibited from export as of January 1st, 2020. That was within 90 days, so we expect that that's going to be coming out within the next 4 to 6 weeks here. And then finally, one other thing I wanted to mention that's still going on is that EPA was in the process of doing some rulemakings under TSCA Section 6 with respect to a couple of compounds, TCE, methylene chloride, and NMP. And with respect to those chemicals, EPA has advised that it is continuing its rulemaking process with those under the risk assessment process under the prior statute. Just because EPA was in the midst of those, and because it was in the midst of those, it's going to continue those. I believe it anticipates finalizing those rulemakings yet this fall. In a slightly longer term outlook, so looking at it about 6 months, there are a number of additional requirements that are going to be coming up. First, with respect to the initiation of those risk evaluations, Amanda mentioned that we are going to be, that EPA is required to initiate risk evaluations for 10 of the TSCA work plan chemicals, and so that has to be completed within 180 days. Now, one of the things that's kind of a benefit here is that because the statutory change was so long in coming, EPA had seen this coming and seems to be fairly well prepared, at least for these initial actions. And so there has been some information that EPA released that it expects that it will be able to release those initial 10 chemicals probably even in a shorter time than the 6 months. So those may be coming up pretty soon. And EPA is going to be required to publish a list of those chemicals that it's going to initiate its risk evaluations for. Also within the 6 months, EPA is going to be required to kind of basically take an assessment of what it's required to do under this new statute and just report to Congress on its ability to implement those new mandates. In addition, there are also some requirements in the next 6 months related to review of small business reporting and record-keeping requirements. So under the new statutory scheme, small businesses have different record-keeping requirements, and there are different means for qualifying as a small business. And so EPA is going to be promulgating those within the next 6 months. And then just as context, under this new statutory scheme, there's a requirement that that those be reviewed again subsequently every 10 years. So within 1 year, there are a number of additional requirements that are going to go into effect. So, with respect to mercury, this first bullet here, that is actually less than 1 year, but I didn't want to put a whole slide just for this one April of 2017 date, so I slid it in here at the beginning. And so what's going on here is that EPA is going to be required by April 1st of 2017 to establish an inventory of mercury supply, trade, and use in the United States. Again, mercury was one of the focuses of some of these amendments, and so some of these requirements are sooner than for some of the other chemicals. In addition, within a year, EPA is going to be required to publish a final rule for the active TSCA inventory. As Amanda indicated, there is this change here where EPA is going to be looking at active versus inactive chemicals. And so within a year, it's going to be required to kind of publish a final rule to reset what the active chemical list is. And again, the purpose of that is really because EPA is going to be required to evaluate those active chemicals for risk evaluations. And so it's just resetting that so that it can establish what chemicals are within the scope of what it's going to be looking at. Also within a year, there's going to be a requirement that EPA issue guidance to assist industry requested risk evaluations. So one of the changes here is that industry can request risk evaluations, but in order to do so, the statutory change requires that EPA facilitate that by issuing some industry-specific guidance so that industry knows what kinds of information it should submit with respect to those risk evaluations. Also within a year, EPA is going to be required to establish its Science Advisory Committee, which is expected to assist EPA with identifying chemicals and questions or issues to address. So also within 1 year, what will happen is, within 6 months, EPA was required to have initiated its assessment of those initial 10 chemicals. They'll be publishing the scope of their assessment within a year. For risk-based screening, they will be required to promulgate the rule to designate chemicals as either high or low priority, and Amanda had talked about that in greater detail. In addition, EPA must issue a rule for their risk evaluation process, which is how it's going to conduct its risk evaluations, and that's going to be required within a year. And finally, I have here fee rule with a question mark. And the reason for that is that under the statute, there's no specific timing requirements for when EPA is required to establish fees under the new statutory amendments. However, in light of the fact that there are a number of additional requirements that the agency is going to need to be able to conduct, the agency has indicated that it's looking at that as being a year time frame also, because it will need those fees in order to support its efforts to implement the new TSCA requirements. So within 2 years under the statute, one of the changes that is pretty significant also is that EPA is required to move away from testing on vertebrate animals. And so within 2 years, EPA must develop a strategic plan to promote development and implementation alternatives for testing that would reduce animal testing. And so that will be coming up within 2 years. Also, there's going to be some additional requirements with respect to mercury use and reporting rules. So for a 3-year outlook, there are a number of chemicals that are listed under the statute or that are referenced under the statute as being eligible for an expedited action. And so those that are listed on the 2014 work plan. And I say here certain chemicals because I think, as Amanda indicated, there are a number of those chemicals that are that bioaccumulate or that are persistent or for which exposures are a particular concern. And so for those chemical substances, EPA is going to be required to promulgate rules for their evaluation within 3 years. And then also within 3.5 years of the amendments, EPA must have identified 20 high priority and 20 low priority chemicals. And as Amanda indicated, that is going to be kind of an ongoing cycle. So with respect to the longer term outlook, and this is kind of starting to move towards some of the implications for industry. There are a number of changes under the Act, but it's probably going to take approximately 4 to 5 years to complete the first round of risk evaluations and to see what conclusions come out of that. In addition, every 5 years, EPA is going to have to report to Congress on its capacity to actually fulfill its obligations under the Act. And with respect to CBI longer term, every 10 years, EPA is going to be asked to reevaluate CBI requests by submitters. If what will happen is, I believe it's 60 days out, EPA is required to provide notice to CBI submitters that their 10-year period is expiring. Within 30 days, CBI requests must be received, and then EPA has those 30 days to reevaluate whether or not that CBI claim continues to be substantiated. Here, actually, we're going to transition to talking about some implications to industry. So some of the near-term impacts. So first of all, one of the things that's going to be necessary is to submit information on active chemicals. So industry is going to be required to take a hard look at what chemicals they're manufacturing, using, or otherwise or importing, and make sure that EPA gets those on the active chemicals list. In addition, to the extent that industry is considering submitting pre-manufacturer notices or significant new use notices, those submissions are immediately required to comply with the new requirements that Amanda referenced. And similarly, CBI information is also going to you're going to be required to submit that substantiation information right away, which is again a change under the new statute. Additional implications for industry are that there has been an expansion of EPA's order authority. So this is something that has been talked about a lot, and that is that there's been this change that is likely to increase enforcement and information requests. So there are a couple of changes that are relevant. First of all, there is seemingly a somewhat lower burden for requiring data generation. It's going to be a need standard for information gathering, and so it's expected that there's going to be increased requests from the agency for that. There's also going to be a relaxed cost-benefit analysis. There is still an element of the review that will focus on that, but the change here was really intended to get to a risk-based standard that makes it more likely for a chemical to be subject to regulation. And one of the other significant changes that's going to possibly impact industry is that EPA is no longer going to have to do this through rulemaking processes. It's much easier for EPA to issue an order. So to the extent that that it wants to make a change or require certain action, it will be able to do so by order, very specifically under the new statute. So that will most likely make it easier for the agency to act. Also, so with respect to the prioritization process for active chemicals, to the extent that you're in an industry where there are high priority chemicals, that may have an effect because in the short term there are going to be data requirements. There will also be publicity and press associated with that. But that being said, there's still EPA is still going to have to do a number of things at one time. So it's unclear yet to what extent the process will actually speed up any focus on certain chemicals. There are obviously a number of chemicals that were already undergoing evaluation or that were on EPA's TSCA work plan list. So to the extent that that they're already listed, it's unclear whether or not there's actually going to be an increase in the timing of when those would be reviewed. But one other change that is of interest here is with respect to risk evaluations and industry petitions. As Amanda noted, there is now the ability for industries to specifically request a risk evaluation of a chemical. And there are going to be both pros and cons associated with that. To the extent that there is concern about a chemical, then you may be able to speed up the review process by requesting the review. There are going to be fees and compliance costs associated with that, but the certainty associated with finalizing and getting that chemical substance through the risk evaluation may ultimately merit those costs and fees. Also, with respect to articles, there is not really a whole lot of change with respect to the regulation of articles. That being said, this is quite a substantial change in the overall structure of the regulation. And so it's anticipated that EPA may renew its authority to possibly regulate articles and the chemical substances that are in them. Also, again, the EPA's ability to collect fees. Now, when requiring submittal of pre-manufacturer notices and significant new use notices, there was a fee structure that was in place. However, it's anticipated that there are going to be a number of increased fees, especially with respect to risk evaluations of existing chemicals. And so there's concern amongst industry that could possibly impact development costs. But again, it's the tool that Congress provided to EPA so that they could actually have the resources necessary to fulfill their obligations under the Act. And actually, at this point, we're going to take a brief break for the CLE polling question.
Okay, at this time, we're going to take a short break, and I'm going to read the CLE code for the program. If you need CLE credit today, please enter the 5-digit code into the polling question on the screen after it's announced and press the Submit button. The code is 1B0NW. Again, that's the number 1, the letter B as in bread, the number 0, the letter N as in Nancy, the letter W as in wind. 1B0NW. Again, if you're seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly for those seeking Kansas, New York, and New Jersey CLE credit. In addition to the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource widget. As a reminder, the certificate of attendance will be distributed to eligible participants approximately 8 weeks after the video conference via email. At this time, the polling question is now closed. I would like to return the program back to Sarah.
Thanks, Megan. So just continuing on with some of the implications for industry. Again, one of the big changes here is with respect to the confidential business information requirements and that upfront justification. The requester is going to be required to submit in its CBI request information to prove that it took reasonable measures to actually protect the confidentiality of the information that it's requesting CBI treatment for. It's also going to be required to show that it determined that that information is not required to be disclosed. So if, for example, that information is required to be disclosed under some other law, then it's not going to be eligible for CBI treatment under TSCA. In addition, there also has to be a reasonable basis that the submitter believes that disclosure is likely to cause substantial harm to their competitive position. So it can't just be that they want to keep the information confidential. You have to be able to demonstrate that it would actually harm your business, your industry, to have that information be available public. And finally, you have to be able to demonstrate that the information is not readily discoverable through reverse engineering. So if someone could easily figure out the information through reverse engineering, it's not eligible for CBI. I do note that these requirements are generally consistent with the existing requirements, but the fact that the upfront justification is required is the new and kind of most significant thing. It's also relevant to note here that with respect to the chemical identity, it's necessary that it include a structurally descriptive generic that EPA may disclose to the public when requesting that a chemical name be treated as confidential. So there has to be a way to describe it to the public in a way that's generic enough that doesn't conflict with CBI and that allows EPA to provide that information. Again, there's this 10-year period during which the justification is valid, and then following that, industry or submitters will be required to resubstantiate those claims. So every 10 years that will come up. There's also a number of types of information that EPA is not going to generally not going to be requiring substantiation information for. So for instance, any process-specific information about how a process is conducted, marketing, sales, and sales information is generally considered to be CBI. In addition, any information that would be submitted identifying a supplier or a customer, the details are, of the full composition and percentages for any mixtures. And then in addition, also with respect to specific information about the use function of chemical substances or the specific production or import volumes. So with respect to import requirements and export requirements, they generally remain unchanged, but again, there are going to be more chemicals that are going to be subject to regulation. So it's likely that there may be some impacts to industry with respect to that. State laws, Amanda did a great job of touching on this, and in general, under the new TSCA, there's going to be some possibility for some preemption. But again, that is going to be limited to spaces where EPA has acted. And there are also limitations for certain laws that are going to be grandfathered. Most notably, California Prop 65 is grandfathered in under the amendments. There was a lot of buzz in industry as to whether or not that would still be out there, or if this new TSCA would preempt it, and it does not. And then finally, I just thought it would be helpful to just finish up by discussing some best practices. So going forward, it's important for manufacturers to know how does this impact your business? Do you use a chemical that is likely to be a high priority chemical? Do you use a chemical that you are concerned about and may want to consider being proactive and conducting a risk evaluation proactively to resolve any perceived concerns about that chemical? And another thing that is something for folks to consider is opportunities for cooperation and coordination, either amongst industry groups or other partnerships. There may be opportunities for that. And with that, I'm going to turn it over to Megan for any questions and answers.
I do not see any questions in the question widget at this time. We invite you to contact our speakers today if you have any additional questions or would like more information on any of this particular topic. This wraps up our web conference today. Just a reminder, today's presentation and attorney affirmation form can be found in the resource widget. At the conclusion of our program, a questionnaire will appear. Please take a minute or two to give us your feedback about the presentation today. It is very important to us to know your thoughts and helps us to shape our program going forward. If you have any questions regarding CLE credit for this program, please contact Megan Burton at mburton@foley.com. As a reminder, CLE processing takes approximately 8 weeks. Eligible participants will receive a certificate of attendance via email at that time. Thank you for your participation.